For judgment, OTAPL 42 of 2025 and OTAPL 31 of 2025.
From the above quoted observation of the coordinate bench, it is exposite that the FE content in IOF is to determine on the basis of WMT and not on DMT. And in view of the decision having taken this regard and in absence of any materials forthcoming before us to take a different view, the said point having settled cannot be debatable, one, nor it invites any different opinion to be arrived at. The Committee of the Judicial Discipline demands the uniformity in the proposition of law, and the judgment of the coordinate bench of the court binds the other coordinate bench. And then I have taken that in view of the discussions, we do not find that the instant appeal involves substantial question of law under Section 130 of the Customs Act. The appeals are dismissed in order as dismissed. Give all the memos. Give all the memos.
There is the direction to leave this.
Give. Give. Let us see, sir.
Yes.
Beg your pardon, urgent matter.
Give.
Tender matter.
Yes, give. Madam, give.
Had to be taken a smaller lot.
Let us see. Let us see.
Item number 2.
Why it is appearing? What? Just wrongly. Yes. What is this? This judgment which you delivered was with another bench and now it is listed here. Yes, sir.
Item 2, sir.
I'm appearing for the report number 3.
From the last appeal.
Special notice you have carried. Special notice you have carried.
Special notice.
Last application you wanted me to.
MSME.
MSME.
Yes. Who has floated the tender?
Floated the tender,
Protect the tender.
Indira
That
Gandhi.
is complete time.
Indira Gandhi.
Who you are representing?
I am representing.
There may be permission.
So the only point which he raises that he is an MSME, and according to the MSME Act and the rules, they are not supposed to submit the EMD. That is an exemption.
But you are absolutely seeking the nature of the tender. It is an open tender. And it is
Correct.
applicable to
So
all.
open tender, there is no difficulty. Everybody will come and participate. But he can also be permitted to participate. But the conditions which you want to impose.
That once he has participated in the tender by submitting the exemption certificate along with the tender proposal, then matter would have been different. He has not participated at all.
But he is going because the time has not elapsed.
The time has elapsed 2 days. Today's time is being elapsed.
This is still continuing, sir.
No.
Today is the last date.
Today is the last time for the week of the tender.
No,
4:30.
4:30.
Correct. So we take it that if he goes and apply There is no difficulty with the exemption claiming that he is an MSME. No problem.
Sir, what I can.
That is what we say. There's no, that's why we say that we will go and file. He was feeling difficulty that you will not accept because the conditions are such that you will not accept the bid. Only thing is acceptance of the bid. Whether he will get it or not get it, it is your decision. Definitely you will go who is the lowest one or the highest one. I do not know what is the nature of the work. So you will give it. They do not have any special character that they will be awarded, even if their price is very high or a very low.
But the tender was protected on 2/7. And he waited for 22/7 without participating.
Sir, he has come before the last date of submission of the tender. Today is the last date. 2 days before he moved it, but we wanted you to come here just to apprise you that this is the condition, this is the law. If he allows, at least that tender should not be rejected on the ground that it does not contain the EMD. That's the only thing. No, nothing more, nothing less. Otherwise, he has to compete. If the price is not matching, then what more?
Also, can you pass that order? Also, can you see that?
What? Show us.
The paragraph 12 of that's 2018 volume 8 FCC.
Please.
Was that?
Yes. Paragraph
Paragraph 12 and 20.
12.
Paragraph 12 and 20.
Yes. Sir.
This application.
Yes.
May I please?
Yes.
This application was registered by the applicant by filing an employer application. The appellant asserted that respondent choose to remain silent.
No. Please, you cannot understand. When it was, if you go by a tender, please consider it. Come to paragraph 11. You can't avoid it. It says in consonance with the tender document as uploaded in a portal, technical bids were opened on 5/1/2017. The financial bids were opened on 29/3/2017. And it is only thereafter on 25/4/2017 moved the application. So it was after when the entire process was complete. Here it is not completed. It has not started as yet. That is what I'm saying.
Small friend. Person allowed is residing in Butla.
What? No, we can't extend the time, sir. We will not extend the time.
At least the last time.
Whatever, sir,
The last
you'll
time.
have.
The time is 4:30.
Sir, when he is pursuing his remedy before the court, then he has to be there.
So
You can't.
At least this 4:30 may be made as 5:30.
No, sir. We will not. We will not. We will not.
Take at least 4-5 hours to travel.
Whatever, sir, whatever he has to.
In new day.
When you know that this matter is fixed today, then at least to show up on a fide, he would have been ready with the tender document. Should be ready with the tender document. And you know the court has already expressed the mind that if it is a law, then why? So no problem. We will not extend.
And another mode was not by registered post or speed post. So that will not be possible in the course of the day. So
What?
At least because the mode of sending the tender was either by registered post.
It is sending within the time or receiving within the time.
No, it's by registered, it's undersigned up to 31st of
Must reach.
July at 4:30 by registered post or
Must
speed
reach
post.
the office of undersigned up to 31/7/2025.
It's up to
4:30 PM by registered.
That is the word is reach. So it has to reach. So you go and file it by hand manually.
Your lordship will only visit.
No difficulty. There is no problem. Where is the exemption under the law?
Your lordship would appreciate.
File law.
And so far the central government is concerned with the phase 35 months. And it should reach series phase 35. third line. Safeguard, to safeguard.
Just 1 minute, sir.
Please, sir.
Yes,
To safeguard the second unnumbered paragraph. To safeguard against the bidder withdrawing or altering its bid during the bid validity period in case of advertised or limited tender inquiry. Bid security, also known as earnest money, is to be obtained from bidders except micro and small enterprises, MSEs, as defined in the MSE procurement.
so this is there
This is
already.
by the central government laws.
Yes,
So
and
for-
now the state
The
government,
state government laws is at page 38. Page 38 and if 4 series,
page,
38.
yes.
Paragraph 4. I'll begin with the
No, no,
paragraph.
I understand.
Government has been pleased to exempt earnest money for local MSC. There's the second line now. With a view to extend support to local MSCs in marketing their products to various government departments, government has been pleased to exempt earnest money for local MSCs to participate in tenders of government departments and agencies under its control. Then it continues, my lord, exemption of from payment of earnest money and concessional payment of performance security. I'm not concerned with performance security. I'm only concerned with this EMD, my lord. And this, my lord, this was again, my lord, repeated, my lord,
Shall be exempted from payment of the earnest money,
Earnest
one.
and if the lordship would appreciate, at page 42, this was intended, you know,
Addendum,
at the last line, and statutory or autonomous bodies. So Indira Gandhi Institute of Technology is an autonomous institution. And if you go back to my lord, page 38, the lordship would see at page 39, this copy was also forwarded to registrar of all universities for information. The first copy means registrar of all universities for information.
no, I'm just trying to find out.
The copy forwarded to this memo number 21927.
Yes, I'm just looking at it. Which line?
So the last line. Gopabandhu Academy
Yes.
of Administration, Bhubaneswar, registrar of all universities for information. And so far as CORAM is concerned, so far as this particular institution, opposite party number 3 is concerned, it is an autonomous institution. And I have that page 44 rules. It's on their website. It's an autonomous institution affiliated to the Biju Patnaik Institute of Technology. BPU, yeah? It's not. I'm sorry. It's an autonomous institution. Page 44, your lordship would see.
No, it says an autonomous institution of the government of Odisha.
So, my lord, my
This is already
understanding
there.
was the central government as well as the
Whether they are affiliated to any university or not, is immaterial.
Well,
Only
so they are-
the character must be an autonomous.
So my humble submission of the central government as
And where is your MSME certificate?
MSME certificate is annexed to one Udyam Aadhar Units.
Where is that?
That is not at page 18 annex to 1. Udyam registration certificate.
It's micro enterprise.
It's a micro enterprise. And there are
Where?
My lord, so you'll also see the registration number. The name of the enterprise is Moon Silver.
Yes.
Then my lord's major activity services.
Yes.
And date of incorporation is 18/11/2012.
Yeah.
And if the lordship would come down to the bottom of the page, date of Udyam registration is 3/5/2021.
Yes.
I am a micro service enterprise with a registration certificate under the MSME Act.
Look.
Or in case that it is not accepted,
No,
it's not applied.
But we are recording that we know. First of all. The writ petition is filed at the behest of the will have to vary the terms of the tender, but which we cannot.
The
That
peculiar
is up to him. There is no difficulty. It's a mutual one. If he says that 5 minutes here or 10 minutes here and
I'm
there,
just praying for 1 hour.
that is up to him.
I'm just praying for 1 hour's grace. I'll pray.
That is up to him.
I think
that is up to
him. Because he'll be straggling from
We will not say anything.
Burla to
We will
Dingana.
not say anything, to be very, because we cannot vary the terms of the tender.
Well,
We
sir,
can't vary.
That is something
Right.
for an urgent copy and let my learned friend also.
This is,
take it.
I will implement immediately.
yes, immediately. It's an open,
Even if order is uploaded late.
It's not
on the-
signed, I will immediately. I will.
absolutely, she's tell them. And
At least half an hour.
consider his prayer.
I think my learned friend is gracious enough to will consider.
No, that's true. That he will take care of. We can't say anything.
Right.
For a direction to the operating partner over 2 meters. Dispose of the uninstalled tools, which is pending since
What is this annexure to?
annexure 2 is the some peoples of the said village have forcefully occupied the land reserved for Gocharo and Panina. Non-building. Therefore, the villagers are facing a lot of trouble to get their.
Who are you?
We are the villagers,
How many?
4 people. A number of the people have made a recognition. Out of 4, I have filed this retaliation.
Others are unable to approach the court.
It's a lady, some of the lady has therefore the petitions are written through them.
That is up to them to take a decision. What is the right? If somebody has blown the whistle, then you'll have to take. If there are encroachers on the government land, then have you made any preliminary inquiry that whether they are the encroachers or they are not encroachers?
The encroachers have been added as party to the present proceeding as OP number 4, 5, and 6.
Have you served the notice on them?
First came to this.
The notice upon them? You have chosen a wrong bench, sir. I do not encourage the concept of consideration of representation and disposal. I am absolutely against this notion. If you have a right, I will declare your right here and now. If you do not have a right, I will nib you in bud here and now.
The remarks column of Aroa, almost for the plots behind the.
It shows that this is really in a behind the
One plot is Gochar and the other 2 are Nala.
Sarado Dui,
Sarada.
agriculture,
Yes.
agricultural land.
belonging to the government. Have you identified the number of the plots?
Yes.
Yes.
So please make an inquiry. We are giving a notice on them, and the state is also directed to submit a report. Whether the allegations made by the minister has any
One of the plots.
come.
Item 5.
And Gramya Jangala is also banned the call.
Yes, only question
Right.
three plots, 320, 323, and 320.
After all, the larger issue when
Madam.
other lands of the government is also found to have been enclosed. Take steps. Good.
Five, sir.
May I please, Your Lordship?
Yes, what is this?
This is a fresh contempt, Your Lordship.
Fresh content means.
Your Lordship, first time listed before. The opposite party
Now,
not
Very difficult question. It is a first contempt or a second contempt?
first contempt.
Sir, this is a unique thing I have to learn in so many years.
Sir, after you bring out new law, date of death of the government servant is the cut-off date. As on that date, whatever law was prevailing on that basis.
It's a compassionate appointment.
Yes.
That is, it didn't, it is, it's a case of compassionate appointment. Then you.
So it is in, so the order is in view of judgment in Bindusagar Samantarai. Right. I think Bindusagar Samantarai and division bench. We have confirmed that it is date of death or date of application. But you have brought out subsequently the rules saying that restoring back to 1990 rules, saying that 1990 rules were in vogue on the date of death. Then the appointments will be considered, the application will be considered in tune with that.
Yes, sir.
So
Yeah, I'm
you,
not on there.
that's,
No, there are a recent judgment also. And Santosh, you will find that.
Yes.
Then Bhimappa, alias Bhimappa is also a very classical judgment of the Supreme Court. I think 2023 or 4. The Supreme Court has, I think he has considered all the judgments which have been delivered by the Supreme Court on an issue, whether the rule which was prevalent at the time of the death
Yes, sir.
shall be followed, or a rule which was prevalent at the time of filing an application is to be followed, or a rule which at the time of consideration of an application is to be followed. These were the three principles which were there, and we assimilated it, and the judgment is in Bhimappa that the rule, ordinarily the rule which was prevalent at the time of the death should be followed. There is a rider, sir. If a subsequent rule is more beneficial to the person, then that subsequent rule should be followed. And if it is detrimental, then the old one.
Yes, you're not saying that also. That judgment I have gone through. I was not on that point. I
What
was
is
on the
this?
point, this order passed by the Honorable Court was on 5th October 2023. Under section 20 of the Contempt of Court Act.
Limitation. There is one special bench judgment of the Calcutta High Court. Do you know?
No,
That section 5 applies in a contempt process.
that I have not known.
I'm just telling you. Section 20.
Madras High Court.
Now I make nothing more. Presided over by Justice K.J. Setgupta. I'm conscious of the judgment of Justice Rumapal. I think in nowadays my memory is betraying me.
Not memory.
on section 20 of the Limitation Act. Because I tell you, the earlier view was that there cannot be any period of limitation for initiation of a contempt proceeding. That is only the High Court. So, High Court. The reason was that this not only originates from a Contempt of Courts Act, but also under Article 215 of the Constitution. Article 215 of the Constitution confers the right on the High Court to punish any person for contempt. So it says that even if the Contempt of Courts Act does not apply, this Article 215 power is exercised by the High Court. So there cannot be any period of limitation. There is no limitation period provided for exercising the power under Article 215. But later on, the Apex Court says no, it should be section 20. Some P, the name starts with the P. Just forget.
I'll try to look at.
Sir, limitation, when you find that they have violated, because the limitation will start from the date of the violation.
And pray, Your Lordship. Your Lordship, the state government has moved before the Honorable Supreme Court of India, Your Lordship.
When
That has been, Your Lordship, that has been dismissed.
was there any stay granted by the Supreme
No,
Court?
No.
On the ground of
According to
delay,
it,
that has been dismissed.
in this order, another judgment has been taken note of. That judgment was SLB with the
No, in this case.
In
In this case, they have gone to the
Yes,
Supreme Court.
yes.
testimony.
Oh, delay of 448 days.
Yes.
So it was dismissed in 2025.
Yes.
Prior to that, you have filed this contempt application.
Yes.
So now it reflects.
On that basis, Your Lordship.
Non-restless, I'm just like, find that judgment.
Follows it. Is it Palapset?
Pallavsit, yes.
Okay.
Pallavsit. They say there is start with the P, is a Pallavsit judge.
Allah.
Thanks to my Justice Umapadhyay is one of the member of the committee.
Justice B.N. Kirpal.
Just the author, but Justice Pan also member of the.
And Justice B.N. Kirpal, Justice Rumapal, and Justice Brijesh Kumar.
Pallavsit. Limitation is introduced. Sir, what to do?
Your Lordship,
In absence of any order of stay, mere filing a appeal dispense with the limitation.
That law.
Or I pray Your Lordship submit one thing, Your Lordship. As per the gazetted notification by the state government, Your Lordship exactly covers this order. May I permit to play
What? No,
the gazetted?
your contempt. Your contempt I am talking about.
Yes.
He is taking a plea of limitation.
Yes. So I will verify.
But again, I am saying you are not remediless.
Yes. Remedy is there. Remedy is there.
Next week, any day, Your Lordship, I will verify some time. As for Your
But
Lordship.
read that Said judgment. That is the classical judgment on that one. And it is accepted now.
Upside.
He believes CANNAV. Allah. And look at the special bench of the Calcutta High Court also. Concept of section 5.
Yes.
After I have judgment was given by Justice Pages and Muktai was.
I think special bench judgment. Let's call the next week.
Item 6.
And this adjustments, yes. And he can.
Item 6.
This is construction to be demolished. Construction has not yet been demolished, my lord, in spite of the fact that an undertaking was given by that person in various proceedings, right from the lower echelon of the judiciary to the higher echelon. In spite of this undertaking, this Cuttack Municipal Corporation is not demolished. And no,
They are in contempt.
I am not in contempt, I am in dead.
My lord. When I say then, if they have, despite the undertaking given,
They have not done it, means they are in contempt.
Well, they're in contempt, there is the judgments of the Calcutta High Court and the judgment of 27, which is
Even the Supreme Court has said
Supreme Court has said.
that even
Right.
a time is what? By it, may I use the word,
It amounts
or
to.
borrowed, give an undertaking, and if they do not give an undertaking, it is also contentious. You have given an undertaking, why you did not reform it?
The private opposite party is given an undertaking.
Oh, I thought the government.
Then
or the municipal corporation.
Well, I'm just explaining in which they have given.
Who are you?
Well, with the pro bono litigations, neither I am a busybody or
No,
interpreter.
pro bono is you.
My lord, this
Pro bono applies to you.
my lord,
But
No,
whether it is a litigation
Well,
by a
this
busybody is the main factor.
not a busybody.
Who are you? I'm just
I am the
asking.
local resident of there, and lot of advocate friends are also residing in that vicinity. And they have earlier approached before your lordship in two petitions.
They are advocates are more solvent to come and this must stand for the cause of the justice. They should not succumb to the illegality. Why? They are not coming.
Because your lordship, all the advocates are present also in the court premises, your lordship. In
No,
two
no.
orders, earlier before your lordship, Justice Raman was a party to both the judgments. There was a direction that the execution proceeding should be expeditiously completed, and thereafter a 6 months target was given. In spite of the fact that the execution, the CNC is not taking any steps in that execution proceeding, your lordship.
Who? CMC.
Tata Municipal Corporation. The instrumentalities of the state, your lordship. Tata Municipal Corporation.
They have a separate legal entity.
Where?
They have. Who is for the Contractual?
Councils there. There was his name.
Just have a glance. How the litigation into your lordships. Just a glance. Page 80.
I was earlier.
We are earlier.
Yes,
Yes, fine.
That's a.
Due to water logging, my lord, so we are facing difficulty. The drain unauthorized construction is there, and that is not demolished.
Already order for demolition.
Yes,
my
lord. Well, I'm just.
Why the Contractual?
Yes.
Is not doing.
This is there also, my lord, I'm just making a submission. My lord, Scotland Municipal, even your lordship has not taken steps in the execution proceeding, your lordship. They have filed up to the level of the Supreme Court.
I have to move the special. Which is
Where is the judgment of the Supreme Court? Unauthorized construction.
Unauthorized construction.
Justice Singhvi's judgment, if I correctly remember.
Well, you can let me.
The judgment is very clear, sir. If you look the first paragraph that supports you.
That judgment you're not supporting on.
Impact Mukherjee versus Kolkata Municipal Corporation, on an unauthorized and illegal construction.
That judgment I don't know.
You serve the notice and come back to this.
Well,
There is an authorized construction, it has been declared as an unauthorized construction. You can't show, I would say the apathy or dormancy in this regard, you will have to remove. The Supreme Court has come very heavily on those unauthorized construction. Had it been a case of a slightest deviation, he's already obtained the permission, but there was some deviation, I can understand. These are all technical thing, but where there is nothing and they have come out, why?
The construction has been made in a public land, LLC.
No, what happened before the Supreme Court,
They lost. Well, Supreme Court they lost. Supreme Court they lost, LLC.
Municipal corporation has not yet taken any.
That is what is there.
There is
Proceedings are in.
Yes. Annexure 8, if the Lordship will see, Annexure 8,
When,
already a execution proceeding since 2019, that is.
wait, that is what I was saying.
Yes,
That is-
CMC has to answer.
I invited his attention, he has not brought the exact judgment.
CMC has to answer.
Obviously, you don't have the liquidity. That's just single judgment.
Well, I saw the copy to Mr. Mahadipli Notice. I'll take notice, sir.
Notice, sir, each time you are giving a shorter one.
Items.
I'll take notice.
Who is CMC?
Well, 2 to 8, you will also take the notice. 3 to 8.
And your allegation is that the corporation is not proceeding with the execution.
Only 2. Because this.
Give notice to all of them. Once you have implemented, you are.
But by special person, that I'll just tell you.
Yes, please. Special person.
Item 7.
I filed an application, Lordships, on 6/5, directed me that you deposit the 50% of the demand. Not, I have got instruction that he has not deposited, but there is some dispute that says I filed an application today. Lordship will grant 7 days more time that I will deposit with an undertaking.
Yes, what is
Right, sir.
Because it's a dispute between the partners here.
Yes. Because
He have directed him.
no number. Today, yesterday, night he came to the court.
Listed on Monday.
Lordship.
With the number.
Yes.
Because we have.
Yes, Lordship. Yes, Lordship. I'm filing.
Item 8.
Your Lordships, I'm appearing on behalf of the petitioner. The petitioner is Background Technology Private Limited, who deals with background technology private
Is
limited.
there any change in the name?
No,
Yes.
Lordship, the petitioner deals with the installation of CCTV cameras. Lordship, the petitioner applied for 4 government tenders. And the rejection order.
Is there?
Yes, Lordship. Page number 102, serial number 11, Your Lordship.
Disqualified due to non-signing of the digital signature in all the documents.
Yes, sir.
Mandatory in the tender,
Yes, Your Lordship.
so why you did not put the digital signature? Did you put a original signature? Because it's online. so you-
Yes, Your Lordship. And also we have the digital signature, because without digital signature, it cannot be uploaded. According to the rules mentioned in the ATCA, It's clearly
But it was
mentioned.
uploaded.
Yes, Your Lordship.
So according to you, you have put your digital signature.
No, Your Lordship. I have verified, but petitioner conveyed me that he did all the papers. But I verified, Your Lordship, and some documents didn't have the digital signature.
Okay.
Yes, Your Lordship. But Your Lordship, it will be interesting to know, Your Lordship, number 3 and number 10. Number 3, Kishore Kumar. His documents were valid, but the essential document, which is mentioned in checklist and also mentioned that it is an essential document. There is no relation to certificate, Schedule A. It is essential to be present in the documents, but it was not submitted, Your Lordship, and it was considered valid, Your Lordship.
3.
Yes, Your Lordship.
Serial number 3 or
Serial number 3.
Which party number 3?
No, Your Lordship.
Serial
number
number
3. Yes,
Okay, then,
they were considered valid
correct.
even
Now,
after non-submission of the essential document, Your Lordship.
correct. Then
Therefore, Your Lordship, the petitioner
there's
is
only
bringing.
one instance you want to cite.
No, Lordship, there are 3 others, Your
Which
Lordship.
is what we wanted.
Yes,
What is the second? This is the first.
yes, Lordship.
What is the second?
Your Lordship, the second one is page number 105.
Yes. Serial number or serial is not coming. Or
Yes,
there.
sir.
Yes.
24. Serial number 24, Your Lordship.
Yes,
RG Enterprises.
correct,
They were also considered valid,
right.
and they didn't submit the same no relation certificate,
No
relationship certificate, Your Lordship.
relationship means
Your Lordship, if a person has a relation with the higher ranks in the department, Your Lordship, and the RG Enterprises in all 4 tenders, they were considered valid and got selected, Your Lordship, in all 4 tenders.
okay.
Your Lordship, that's why, Your Lordship, Your Lordship,
Is it mandatory?
yes, Your Lordship, it is mandatory.
Where do I get all the-
It is a violation of clause 45.
Where is this,
Yes.
window?
Your Lordship, page number 43.
43.
Yes, Your Lordship. Clause 45.
Law 45.
Yes, sir.
Now, tell me that this is what is the essential document.
Yes, sir. Your Lordship. Page number 16.
Yes,
Page number 16. There is a checklist which is provided by the tender. Yes, sir.
it's me from the terms and conditions that in the event those requisite documents are not filed, the tender is liable to be cancelled or your bid is liable to be rejected.
Your Lordship, I understood.
I just wanted that clause. I believe come ready.
Monday, Your Lordship, I will be.
No. One. Yes.
Item 9.
Bless you.
ये जो पेंट होगा सर जो पम्प्स को डेकोरेट विजुअली are doing
Homes, oh, actually. Homes.
Oh, this is what.
Yes, yes.
Yes.
I have already called the superintending engineer. I think it must have been done by.
no it is not done
Not done.
just I had gone there But I was going through that.
No, they will be doing it, maybe for rainy thing, it cannot be done, when it is rainy. The painting, it cannot, but it will be done. I have already told them that will be done. The ବର୍ଷାରେ ରଙ୍ଗ ହେଇପାରିବ।
ହେଇପାରିବ ସେ ଲଗେଇ ଦେଇପାରିବେ ସେ ଲାଇଟ୍ ଗୁଡାକ ଆସୁଛି ଲଗେଇ ଦେଇପାରିବେ ଲାଇଟ୍ ଗୁଡାକ କେମିତି ପାରିବେ?
So, I don't have any answer.
No.
He wants that the workers will be work, so when it is heavily raining.
My lord, I bow down to whatever.
You should say that the light is
Reasonable.
No, no,
That is what I am asking, whether it is the fluorescent or is the ordinary paint?
That's to be fluorescent, my lord. It's
You notice you were saying that it is not glowing.
Yes, my lord. It is not at all there, my lord. Nothing is
No
there.
painting is there.
No painting is there. Neither fluorescent, nothing.
We can decide whether it will.
No, 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 I am not deciding it.
No. It
Must be for the road safety and
because
for
of
the, yes.
the insufficient lights. Now these speed breakers may cause lot of accidents.
Right.
There is no difficulty. So he says that it is not there. We suggested that if it is done by a fluorescent, unnecessarily lamppost will incur a huge cost.
That the very day when your lordship directed, I called those officers to my office also during the lunch hour. It is already directed. They will do it. They are also concerned for the safety of human beings.
This is the issue.
Today I may be.
10, 1, 0.
Well, today may I permitted to file my still bullet points in a preliminary rejoinder to this case. It's up to government. That much this case. 0.2.82. That is at phase.
Yes.
I will kindly see page 43. That is the clause. They have stated that 5 financial years, 2018-19, 19-20, 20-21, 21-22, 22-23. Page 43.
Yes.
43.
Yes.
And they have stated that the bidder.
3 years experience.
3 years, any 3 years between this 5-year financial year. They have not included 23-24 or 24-25. For the first time, my lord, in the state of Orissa, this department floated e-tender. So this is all manual tender up to 2019-20. My lord, in the counter, they have admitted there was no tender for 2021, 21-22, 22-23. They have admitted in the counter. My lord, that is at place. So without between 5 years, 3 years, they have not floated the tender, and I have given sufficient evidence that the milk union.
Ma'am, the rejoinder has been filed right now, madam.
Just in court.
That is in a bullet point. I have not annexed anything.
It's an affidavit. We have to give a reply.
But my lord, that don't.
It's in form of an affidavit. We'll have to seek instructions about the rejoinder. madam.
Until
You have used the word rejoinder and affidavit.
that's my mistake, ma'am.
That gives encouragement.
That's my bad, my lord. The letter on be Monday, because
Monday name, Monday.
Tuesday.
Friday. Wednesday.
Because 8th is the last, is the 7th is the last date of submission. So before that, it can be fixed. 7th is the last date by through original norm. They have issued 7th as the last date of submission.
She wants to listen. Yes, and who quick and not sure. 6.
6th.
Item 11.
This is a PIL. Fight against the decision of the Odisha government to suspend the ration. To suspend the ration. PDS ration.
No, I understand.
For 3 months. For 3 months.
Public distribution.
No, public distribution, I know.
Yes.
Why?
My lord, they say that there are large.
Distribution scheme, that's why I am asking.
My lord, may kindly turn to page number 21 while I am
Why did that? That's why
My
I
lord.
put a question.
Yes. They say that there are in these ration cards that are issued, there are some ration cards which are problematic, might be belonging to dead persons, or there are ingenuine persons who are issued with ration cards. Now, the way they wish to rectify it is by suspending ration cards for 3 months for everybody, and they expect that only genuine people will approach them and they will verify their KYC, and after that they will resume the PDS system. My lord, may kindly visualize, I have filed another PIL that is number in WPC 18860 of 2025, complaining therein, my lord, that the government has not opened enough fair price shops in the vicinity of people, where people in the tribal areas have to walk 20 kilometers, 30 kilometers to get their PDS units. Now, if this is the way they want to verify the KYC, e-KYC that way, well, large number of villages do not have electricity in this state. Now, they doesn't have electricity in this state, but they want to
No electricity.
in number of states.
Electrification, I think the department they have taken a drive that they will cater the electricity.
My lord.
To the first citizen.
My lord,
Or sorry, the last citizen.
my lord, the data, your lordship, have collect
This is really a surprise to me because now there is an initiative every part of the country to tackle the electricity system. I'm told that there are certain pockets here in the state where the electricity has gone. It's really surprised.
Some delay. Nearby also.
It is now an essential supply or essential.
So your recipe is absolutely correct. I have seen blood even 30-40 kilometers away from Cuttack, they didn't have. Your recipe is absolutely correct.
Even though they are installed,
Let
connectivity.
your recipe is absolutely, I do agree. I have also visited many rural areas. Your recipe is correct. But the question is, Milord, we have been, I will give a Milord a detailed data sheet how it was being neglected for years together. We have been taking many steps, even for some projects are also even coming.
Rural, I think rural
Electrification program, it's a national flagship program. Hisli and Pani, these are all central.
All the
Crores of rupees they had brought. It was unutilized electricity and water. That's a central government flagship program. University is absolutely
that is what I.
they didn't execute it here. There are other reasons I can tell now. Here, I can make other statements. But so far, the last 1 year progress is concerned. If your RC wants, I can produce a fact sheet. But we have taken during the last 1 year. But here the issue is different. I'll go to that.
Oh, I understand.
Yes.
Right.
Is
This
so
is absolutely
yes.
a digression
Right.
from the core issue.
Right.
But once he's after a particular word that
No,
could
no,
lead to supply,
exactly.
what is this reality?
I do endorse his submission also. 60% of the rural areas in
Want to emphasize that once e-KYC is to be done, it has to be through connectivity in the internet.
every block and panchayat headquarter is concerned. That's not correct. He's correct. He's not. Every household, if you ask him, that is different. Every panchayat headquarter, 7,000 panchayat headquarters are connected, and for Subhadra Yojana, 1 crore 20 lakh women have registered through eKYC. For 50,000 that was the manifesto. So that is not the issue. The issue here is very chronic. Around 25 lakh ghost card holders under the PDS system are there. Even government officers, class 2 gazetted officers are also using this. I do not know how it is maybe planted by some people. So we have given them enough time. I'll find a response to that.
No, the only thing is what concerns particularly the wages.
Right.
That the object of providing
VDS
at a very subsidized rate is the initiative of a government just to, may I use that word which should not be appropriate, but I am using it for their animal existence.
No, correct. Absolutely.
It is not that you are uplifting the status or the other economic strata of the people, but it is only for their survival and their existence. You are providing. If you disrupt, because there cannot be a holiday for an hungry people.
No, you are absolutely correct.
Can there be a holiday for a hungry people?
Absolutely.
So she must, I understand, but there may be a ways and out that how to combat this situation. You are absolutely correct. There are many people who are no longer in the world. Since they had a ration card, nothing has come out. Nowadays, that's not my view, but it's just out of the box which comes to my mind. Nowadays, the birth and death are compulsorily registered. Everybody has to register, otherwise they will not be permitted to cremate by courts. Unless that registration is done. So that verification, I think, all the departments are synchronized. I think that can ease out.
Right.
Now, everything is uploaded on the server.
That is exactly what the
If they
department
wanted to synchronize it, you will be able to find out the persons who are already dead and their ration cards are there. That
right.
identification can run parallelly for a time being. But it's stoppage for a three months. Will it be?
No, they have been identified. Double card, etc.
No.
But as relying on
Uniformly, it is a stop. That is
Yes,
what
yes, ma'am.
uniformly not you,
Yes.
but it's not. You are relying upon a newspaper report. What is that? I have
The
to
statement
report
of
on
the minister.
instruction.
Statement of the minister.
No, that's correct. Let me
No. You have to come with a reality.
Right.
Whether any of the persons have been denied
My lord,
the facility of this
That's correct.
ration
as per my
because the government has decided to temporarily
suspect.
suspend this. Then the position is different. What he says is it's not that we have completely stopped their giving, but we have raised certain objections that these persons are alive or not. They have to just upload it that they are alive.
Right.
That is what his initiative must be taken.
Right.
Nobody would be permitted. How the cost will eat the cereals, all the other things.
My lord, one submission. Ghost will.
So should I record that it has not been suspended?
No, my lord, it has been. That is what I'm saying.
Even a genuine card holder is denied of the.
They are in the districts of Koraput and Sundargarh, according to my instruction, the rations have been suspended already.
I have to take instruction. Let me discuss. I do not know.
Please take instruction. If this is there, I think department that requires conscience.
Yes.
Definitely.
And I am also.
You should initiate a
correct.
right parallelly.
That a poor man, your lordship is absolutely correct. There is also a saying in Sanskrit, "Je bhut khita kim nasrati bapo." A hungry man cannot write literature. Anna chinta chamatkara katari kavita kuta. वो तो चाणक्य वाणी. Beloved, I am conscious. Poverty is no doubt painful, but it should not be genuine people. A person, beloved, a government, there are some judicial officers were availing this saying. It came out. Some judicial officers were enjoying this saying.
In the Hindu mythology also, that the chanting of the mantras to please the god is not permissible for a hungry man.
True. That is exactly the same thing I say. The same thing I say. That will ensure no person, beloved, that's a Food Security Act also, FSA. So, beloved, what has happened? Not 20 lakhs, 37 lakh, beloved, ghost cards are there. 37 lakhs.
I appreciate that.
Out of one crore.
There is no difficulty, but the total stoppage is.
No, I'll take instruction. What they have really done.
Should I?
Let me call the Food and Civil Supply Secretary.
Should I keep it on 6?
The same day, that 6 you will speak your panel matter. So,
Take instruction.
Item 12. Item 13. Sir.
Ranganathan Sharma.
May it please your lordship. What is this?
Yes, sir.
Am I audible, my lords?
Yes, sir.
This is the similar to the writ petition. Your lordships were pleased to issue notice on 14/7/25. That was for the 3rd year of the mine. This is for the 4th year. Your lordships may recall, I'm not saying that I mentioned that there is another writ petition for the 4th year. I'm filing it separately. This is for the 3rd year, and the order has been handed over to your lordships by my colleague in the court. This is for the 3rd year. Your lordships issued an order and made some observations in paragraph 8. I request, this is for the 4th year, a similar order of demand, no reasons given, and it's violative of the rule is.
So this matter, the other matter is fixed on 11th.
Yes.
So we can also tag this matter and to be taken up on 11th together with this.
Please, Madam. And the same observation that your lordship made in paragraph 8 of the earlier order may be kindly made.
Handle to the other side, it said, one after another in the garb of raising a challenge to the statute, they are coming up to challenge this pillar.
But every year there's a demand, I have to challenge it.
But it's a December 24 demand. Not in August, after every day, you're hauling us for the delay and latches.
There is no difficulty, Mr. Advocate General, because in other matters, we have already fixed the matter. We have fixed the matter on 11th. And therefore, because it concerns the same issues, then in that event, it should also
the
be.
Union government is to be noticed. He's challenging a central statute.
No difficulty.
So 11th.
No difficulty. The London DSG is there. Normally, nowadays he's appearing virtual.
He is there.
No, I'll appear, my lord, on the 11th, I'll appear physically.
No. I am talking about London DSG. Deputy Solicitor General. Now he is more tech savvy and he embraces the virtual appearances. Sir, do not scold your junior, sir. DSG.
He's muted, my lord.
Do not scold your junior. Please.
Who's the DSG?
Please unmute your system. Mr. DSG, your system is muted.
Junior will show the face now.
Why are you again muted? Unmuted. Yes.
Sorry, my lord. This is repeatedly.
Why you are scolding your junior? Don't
sorry,
scold
I'm
him.
extremely sorry.
He was looking at the right and scolding, but he is sitting at the left. Maybe some other person.
Sir, the other matter,
my lord,
raising the same issue or involving the same issue is fixed on 11th.
Yes.
So in this matter, you have received the copy.
I don't think that we don't have a copy on this one.
No, we have
Why don't you serve him a copy by hand? Today itself.
We have served everyone, my lord, and we'll serve another copy.
About this present representation 20027/2025, that copy I have.
Oh, you have?
Yes, about 20026 of 2025. Subsequently, if any document is filed, I didn't have, but the original petition was filed by Land Senior. It is copy with me.
Yes, and you are also served with a copy in 19172.
19172, that copy.
Earlier matter, your name appears.
I will check it, my lord. If
On
not
14th.
there, that is yes.
So we are fixing this matter also and permitting the same leave which is granted in paragraph 8.
So that is our demand. So for para it, he has nothing to say on that. It's my demand.
No.
It is not necessary. I don't know.
Please read. I have not said that we are not passing any interim order at this stage. Liberty is granted. If the occasion so arise, he may renew the prayer for interim order. Then what is the objection to this? When he comes for renewal of the interim order, then we'll definitely consider on merit. That is what is there. Nothing. It's a liberty because sometimes a plea is taken since at the initial time you were not granted the interim order, so you cannot. That is what they wanted to have. That
Number 1.
Yes.
But 11, maybe.
The other matter is already in your presence fixed on 11th of August. 11th August.
The central government has to respond. I do not know.
That DSG is ready with the response. No difficulty. He is ready with the response. Yes.
What I am praying, my lord, if both the matter will come 11th, let this Larsime pass any order in 11th. Till that.
That is what I am saying. That is what the senior counsel, Mr. Chidambaram, is also insisting for that.
On 11th, we'll hear the matter.
He's come ready.
Yes.
On a
Yes, my
virtual,
lord.
or physical,
Yes, yes, my lord.
Mr. DSG, virtual mode or a physical mode?
No, I'll physically have there.
Ajay, physical.
Sorry, physically have there.
Yes. The similar and identical issue, which
Just fraction of movement lordship by then lordship
just
let him Monday lordship
no, we can go back after exhausting.
lordship great fruits.
Item 14. Sir.
Page 138 is the improvement.
One,
Page 138, Annexure 11 is the improvement.
10 July.
Right. But before I take my notes to the order here, in a brief, the facts are in this medical college for last 12 years, up to 2024, one particular person was supplying diet to the patients. For last 12
Supplying?
years, for last 12 years.
Dietary supplement. What?
Diet, supplying of diet, milk, bread to the patients in the medical college and hospital. For last 12 years, one particular person was supplying.
Monopoly.
Beg pardon?
Monopoly.
Monopoly. In the year 24 only, in the tender process, this person became successful and awarded with the contract, which is for 1 year. Ending in the month of September 2020. Now, this person was supplied. My tender was questioned before this honorable court by the unsuccessful bidder, and writ petition got dismissed. His writ petition got dismissed.
So you are a successful bidder.
I am a successful bidder.
And you have been doing since last.
I have been doing all these almost two more months only left to be.
Yes.
Now, at this stage, that unsuccessful bidder lodged a complaint against me that the milk and bread which are being supplied doesn't bear the manufacturing and expiry date.
That was the complaint given by them. They inquired into whatever has a so-called notice was given to me. I replied. They did not pass any order on my so-called. Now, shortly thereafter, they gave me another so-called notice, adding 2 more grounds, saying that the dry diet which I am supplying is of low cost. Dry diet which I am supplying is of low cost. And one more allegation was added therein.
That cost means low standard quality or what?
But they say that it is lower cost. That is what they are using the word. But
Yes.
then they added one more alleged lapses on my part, that a dietitian was supposed to be appointed by me, which I have not done. That's the second so cause. Now I replied. Second so cause no order was passed. A third so cause was issued saying that the experience certificate which I have submitted along with my tender paper, the medical college and hospital, high-tech medical college and hospital which I issued, that doesn't tell. A third so cause was issued.
Doesn't tally means?
Means that is what they are saying. They don't explain how it doesn't tally, where it differs. They do not explain. Doesn't tell. Now I replied. After this series of reply, they passed a final order at page 130. They imposed a penalty of 2 lakhs on me. Then they said that the experience certificate do not tally. Third, they blacklisted me for a period of 1 year and floated a fresh tender, the last date of which is first, means tomorrow.
Which department?
Beg pardon?
Which department?
It is-
But it is MKCity Medical College and Hospital.
Who is representing them?
The state will be representing me.
The entire management has changed
No,
of the medical college.
management, it's a government hospital.
The persons who were there in the helm of affair has changed.
I could understand, but continues to say. But again, your Lordship will see, it's a double notice. Third, they are blacklisting me for 1 year, though in none of the so-called notices they have given me an opportunity that you are going to be blacklisted.
There was no issue, there was no.
Nothing.
Nor they contemplated for.
Nowhere. My so-calls have never been considered in the final order.
And your tenure, I think, remained till September.
And that is what they have said, that till they select a new person, I'll continue. In order they have said. And the selection process, last date is tomorrow. Because of this stigma on my part, I am not able to participate.
Your tenure is going to expire in the month
September 25.
So, and you are permitted to continue until the finalization.
Till finalization.
No difficulty. They can start, they can initiate a process prior to this, because you are not supposed to continue eternally for all time.
Definitely.
So they may initiate a process. Now the question is that you are debarred from participating.
That's right. I want to participate in the tender process, which they have done not.
How can you blacklist it? Do you know that what is the nuances of those blacklisting?
That means not here.
And have you given them an opportunity? Have you given them a show cause notice that you will be blacklisted?
Man, in the so cause notice in the last part, no, let's see.
Have you initiated that we may blacklist you?
Appropriate action will be taken up.
Sir, blacklisting is a civil death.
Yes, it's a civil death.
And this is such a stringent one that one should get an adequate opportunity that I have not committed any error.
Exactly, they have
And
used the word debarment.
Debarment, then I give you a judgment, the debarment, I have delivered a judgment. Debarment and a blacklisting has a same connotations.
Let me read it, Lord. Your
Yesterday, I do not know, last week I delivered a judgment. I delivered a judgment on debarment. You appeared, I believe now, or somebody else. So, debarment is a different concept. Still achieve the same destination.
But in the reply to the so-called, they have almost admitted 3 things.
What admitted?
But kindly see the so-called. Where have they used the word debarment? Even that's not there. Kindly see page 20.
Not debarment.
1 second. Your so-called must be received 15 days, received letter. Otherwise, action deemed proper will be taken against you.
This cannot.
Let me read it, Lord. Your so-called must be received 15 days, received letter. Otherwise, action deemed proper will be taken against you.
This cannot.
So far, Blacklist part is concerned, I would take
If a person has committed a grave misconduct, you are still permitting him to continue.
Yes.
Is it not, you are showing a fast and loose? Or blowing hot and cold? Oh.
So only to keep me out of competition.
Oh,
I will take instruction.
no instructions. When is the last day?
Tomorrow is the last day.
No, it will be opened at 7th.
If he cannot make an application, then what you will open? You have debarred him from participating. He cannot offer his, he may again come up. Debarment. No, this is absolutely contrary to the second proposition now. Absolutely contrary. And you are permitting him to continue.
Yes.
Where is my, our judgment? I think my brother was there, or somebody else, Justice Pathak.
And get the judgment.
Your worship, that delivered on 24th July 2020.
That's
Dr. Tranab Mia versus State of Odisha. WTO number
Sitting with
378.
whom? Sitting with whom?
My Lord Justice.
So,
E7, 8th of 2021.
taken into consideration one matter which
I think
originates from
Ponda also we have taken.
from the state of Odisha. That, what is that name?
Ponda.
We take into consideration. And on a doctrine of proportionality, we have interfered in that order.
Yes, you read that para 3, page 138. Not whispered anything from his explanation which he has given. The letter submitted by the principal so is not satisfactory.
On the basis of a cash transaction, what are you talking about?
This letter is not his. That letter is of the other medical college. If that is not satisfactory, how can you hold this person?
It was very interesting.
To read also this paragraph.
That's why I put a question to him.
Let me take instruction.
You take instruction.
This may be treated as
but you can't debar. Then we will impose the heavy compensation in the event if he succeeds. Heavy compensations. Yeah, compensations.
In this manner, sometimes we have the creature of instructions.
So you are, but look at it, you are after all the officer of the court. After going through it, your independent view is also very important.
Yes.
You are not simply a mouthpiece of somebody else or officials. You have the primary duty to help and assist the court to arrive at the correct decision.
Yes.
Can't.
May break on Monday.
Then don't close it. Then extend the time. We'll give you, but extend the time for submission of the application.
Or else take up this matter tomorrow.
No, not tomorrow.
Tomorrow I am not there.
Not tomorrow. Are you ready to submit your?
Yes, sir. May I just suggest that also? Let your lordship allow me to submit it, which will be subject to further orders be passed by my lordship. Let them accept it, let them not reject it.
Give me that judgment. You are.
So this.
to Mr. Naik, it is beyond, it's beyond cavil of doubt that a fundamental principle embraced in a civilized jurisprudence is that a person cannot be condemned nor can be affected by an action without affording a reasonable opportunity to defend himself. The person against whom any action is taken affecting his right is entitled to know reason for initiation of such proceedings so that an adequate opportunity is given to respond. It is therefore essential issue notice containing the grounds on which the authority intended to proceed against the person with clarity, precision, and explicit as an ambiguous narration of grounds is regarded as denial of an opportunity.
That is what I heard. These are my languages.
The Lordship has rightly, in fact, Lordship's language is in tandem with the Honorable Supreme Court judgment also. I have given those notes.
Yeah.
3738. 3738. Absolutely.
Your Lordship's judgment is
I'm taking the printout.
the Supreme Court judgment. I'm okay.
Number
3738.
738.
3738.
I think
That is
UMC Technologies is also considered by me in that judgment.
Lord, here, Lord, UMC Technologies.
I have also considered in that judgment.
UMC Technologies.
Kranti Associates I have taken.
Right. Gorkha Security. Kranti Associates, that's the, in fact, that is what the issue is there.
Correct.
That you will have to give reasons in the so-called notice itself. You will specify the grounds on which you are going to hang the man.
The minister is
show cause reading the argument.
Here will highlight it time and again that responsibility was
Transport Authority.
Yes,
State Transport Authority.
I am appealing. But what happened, after rejection of the bid, the entire fact has been brought to the notice of the tendering government. Lordship, kindly see the pro forma to be submitted.
Sir, then it invites one query to be made by us. If your contention is correct, then at the time when you detected that he was blacklisted, have you intimated to him, giving an opportunity that now this has come, what you have to say about it? he would have come and explained. You cannot just sit over those documents and do not invite an explanation.
So there
You
is,
have to.
man,
It was not that you did not gather those documents or discover those documents. You ought to have intimated this.
he should have disclosed.
There is no format.
He says, because the High Court order is saying that there will not be taken as a stigma for any purposes. So he is not supposed to disclose. Say for an instance, I am giving you an example. Under the Juvenile Justice Act, as I always give, if a juvenile is convicted, though conviction word is wrong, but the statute has used, so I'm using it. Not beyond 3 years. Then in that event, it is the statute says that after this, if he attains majority, if he goes for any public employment, he is permitted to write that there was no criminal offense against or criminal case against. That law permits that you will say no. If the judgment of the court is a law of the land, is it?
Man.
If that says that you will not, then how can you insist upon?
Well, that was not before the authority. While
You ought to have asked for that. This is the document. That may be a manufactured document, fabricated document. Nobody. You should explain it.
That is the declaration submitted by the petitioner.
He says no. Let us see. He says no. But you could gather from some sources that he was actually blacklisted. You relied upon that.
Authority should
Was it not your duty to communicate to him that I have gathered this document? This particular statement is the false statement. What is your explanation to this?
That I think
They would have produced the judgment of the High Court. This is what is the judgment.
Same day we communicated. In same day, 22nd the rejection. You have sought clarification on other document and the not regarding this on same day we communicated and the format prescribed on due date. No, the previous year. I have to go with the prescribed format. If your format is defective, not about previous, how can I be penalized for your format? In prescribed format, I submitted.
What is the information which is sought for? Where is that document? Tender document? Can you show me?
Look, here what's the tender condition or information?
Oh, where is that format? Tender document?
Here what's
There must be a printed format. Where is that?
Page 58, your lordships.
58.
Your lordships, annexure 2.
Oh, this is the declaration one has to give.
Is
affidavit.
Affidavit. Your lordship, the Mrs.
No, I just said. Oh, this is in presente, sir. This is in presente. You just wanted an affidavit that you are not blacklisted or debarred as of this day.
Right.
And he was not. Sir, I have already held in the judges that it is a civil death. That does not mean if somebody is debarred from participating in 1 year, that does not mean that this debarment will carry for all time to come. So that's a natural perpetual death. If it carries. Should not. No, sir, that we can't. We'll have to accept. Other difficulties, no
They
problem.
have not rejected other ground. They have not rejected other.
If there are other grounds, let them know. We will not say, but on this ground we will. Have they proceeded with their tender?
Annexure 1. Annexure 1.
Financial bid?
I have no.
I have to take in person.
We have proceeded.
Come on Monday, we'll see to it, but we will reject this. Set aside.
They may not issue a LOI.
Oh, sir, the financial bid is not open.
Open Miller.
No, he says he has to take.
No, he is open. It is open Miller, but my bid is not open Miller.
Oh, your bid will be open. No finalization will be done. Come on Monday.
Yes, sir.
Thank you, please.
Yes. Yes. Yes.
Item number 1.
Yeah,
What is this contempt?
non-compliance of lordship's order dated 14/5.
Where is the operative portion of the order? Tell me, page 5.
Yes, nurse. Last part, page 46.
46.
Page 46. In the result, both the writ applications are allowed in part. Some contest.
So the age relaxation was given.
Relaxation given that one.
Then what is the allegation of contempt?
Content that order has not been implemented.
Why?
Even if that, you also kindly see, lordship for clarification, the next page, kindly see on page 52. This is the government letter to the OPSC to comply the order. The OPSC said that I will not comply. Also kindly see annexes page 52. We see the correspondence between the OPSC and the government. Referring that judgment, the government said the OPSC to comply. Considering the order passed by the Honorable Court, being the appropriate authority, last para. You are therefore requested to furnish the action taken report compliance pertaining to order dated 14/5/2024.
Yes, they wanted a action taken report.
Yes.
Then
Nothing, my lord. Neither the OPSC nor the government nor the order is still as it is.
what you have done, sir?
You have to take instruction.
You'll have to file an affidavit because in a contempt, the first opportunity to file explanation.
Yes, ma'am.
If we are not satisfied with the explanation, then we will issue a rule.
All that, yes.
So may I say something? In fact, what you have, in fact, that judgment is rendered by me.
Yes.
In fact, what has happened, sir, the CAT has provided struck down the age relaxation. We struck down the order of the CAT.
Correct.
And CAT has directed to publish the result. We have not touched that. So instead of approaching this court, why they will not approach the CAT?
Yeah.
Because there is a provision in CAT rules also.
Abolish.
Sorry. Okay, I thought it CAT.
Yes. So affidavit within 2 weeks.
Yes, ma'am.
Return rejoinder if any within a week and matter to appear after 3 weeks.
Right.
Fix a date so that we'll fix all.
Yes,
the
yes,
stuff.
21st.
21st
21st August.
is make it on Friday.
22nd.
22nd. 22nd August. Item 2.
My lord, 2 and 3 are, my lord, against the same orders. Will draw lord's attention, lord, 2 writ petitions, my lord. The first order was passed, lord.
We just show us the operative portion of the order.
My lord,
Pages.
9/4/2024, my lord, page 36. And this is the second writ, my lord, the second direction by your lordship. Para 5, my lord. It would be on page 37, my lord. As regards by learned counsel, I may read it out with permission.
Whether this representation has been disposed of?
Not yet, my lord. We do not have any information from their side. And this is the second time happening, my
What
lord.
are you doing? Give your explanation.
Item 3 also.
3 also, my lord, same
The
order.
rules and the act provides.
Right. 3 are both same.
Both.
Deeply
Item 4.
Bring the judgment of the pre-judge bench.
Yes, sir.
Bring the judgment. Which judgment? 2012.
My lord, it's
Justice Kapadia's judgment, 3-judge bench.
I will collect it, ma'am.
I just give you, go make a homework. You also, Mr. Das, consider that judgment on a contempt.
Yes, ma'am.
Particularly on this point,
Deeply obliged, Your Lordship.
not considering the representation within the time. Yes, where is the, yes, item number?
Of course.
May I please? Your Lordship,
Where
this
is the operating portion of the?
It is at, Your Lordship,
Oh,
It's
I mean,
actually for dispensation.
is the application for modification?
Yes,
Where is the original order?
Your Lordship, it is 3rd May 2024.
Page.
No, Your Lordship, I'm just saying that the IA that Your Lordships had passed, a modification is made for that IA, Your Lordship.
Six would be.
Which order you want a modification? 5, which date? Where is the annexed?
May.
Where you have annexed?
It is Your Lordship's order.
Have you annexed?
You have asked for a modification of a particular order. Will
Yes.
you not annex that order in your modification application? What are you talking? You are a young advocate. You should know the procedure.
I will annex it. It was filed by the.
This is the first and foremost duty when you take out an application, you annex that order. Maybe a server copy, whatever.
It was filed by the earlier council, Your Lordship. I have recently appeared my
When you have inherited the asset, you must inherit the liability as well.
I'll do it. I'll do it.
So, where is the order? Which order?
It is not, Your Lordship.
Order number?
5.
Five.
3rd May 2024.
So you were directed 1 week time
Yes.
to file the certified copies of the orders under the annexure 1, 2, 3, 4, 6.
6 and 8. Your Lordship, there was a mistake by making the prayer for dispensation, the interim application that was filed by the council, Your Lordship. So the annexures to be dispensed with are 1, 2, 3, 6 and 8. 4 is not required. That's not an order. And under challenge, Your Lordship, are annexure 1 and 8. The others need not be filed because those are already filed with the first appellate authority, Your Lordship, and the revision authority. So, Lordship, may kindly grant me a fortnight's time, Your Lordship, I will comply with this.
If this is really an extension of time, then what modification?
Modification, Your Lordship, for the part where Your Lordship says annexure 4, that needs to be modified because 4 is not an order, Your Lordship.
Once the order has said that you should file a certified copy of 1, 2, 3. 4 is not an order,
4 is not
I
an
understand. Then 6 and 8,
Yes,
why you will not file?
Your Lordship, that is
You
already
should have
filed.
shown your bona fide by filing the same. And then ask for a modification, delete 6.
A fortnight's time.
There
Your
is a default clause.
Yes, Your Lordship.
So show bona fide of filing all those. Where are the certified copy? We will not extend the time. Come with a certified copy, then when?
Your Lordship, may grant me a fortnight's time. I'll.
We are simply adjourning this matter for a fortnight.
Yes.
Again, fix on 21st.
22nd.
22nd. Come with that, otherwise we will not. What I they are in the capital also. That's kind of a certified copy.
Yes.
What is this, madam?
I'm filing IA for recall of order dated 15/5/2024, my lord.
15/5. What is that order?
Mr. S.S. Kashyap running council, on central
So
government council.
that was the instruction,
On the basis of their instruction, matter was disposed of, my lord.
because he has been paid a salary. And his
My
name is
claim-
also included in the pension scheme.
My case is, my claim is the difference in arrear salary from the date of my initial appointment to from the date of regulation of service.
Madam, there are 2 ways. The party can abandon any part of his claim. If you abandon any part of the claim, can you say that this order is to be recalled?
Well, originally,
Metro was, this is the metro.
Who was the conducting advocate?
She was.
You were. So you did not ask for that differential salary has to be paid. You ought to have said so. If you do not, that means you abandon that particular prayer or a relief.
But my claim is before your lordship, before the London State Tribunal, my claim is to regularize my service from the date of initial appointment. And the London Tribunal has directed, page 24, in view of the above, the respondents are directed to take necessary steps and pass orders within 8 weeks from the date of receipt of this order for regularization of the applicants from the date of their initial appointment with all consequential benefits by following the necessary rules with regard to conformment of temporary status and consequent regularization manual. They have regularized my service, but they have not given differential area salary, and my contempt was
But you have said that you have been paid a salary.
Salary paid, I have paid salary, but the differential area salary I am claiming.
It's a separate project.
From 95 to 2023.
Ma'am, your prayer in the writ was to direct the government to regularize your service. And you have admitted in your IA that salary has been, your service has been regularized. So where is the claim of arrear salary?
With all benefits, my
So where is that? Where is your prayer? Neither in the writ nor in the OA also.
No, my lord. May I submit, my lord? My prayer before the
order passed by the
administrative tribunal.
My lord.
So we challenge the order on some other ground.
No, sir. They challenge the order to the.
So this was against the
Contempt and content and to direct. So that has already been addressed to. His service has been regularized, which was his initial prayer.
From the date of initial appointment, my claim, my lord, with all consequential benefits. So I am entitled all benefits, my lord, as per this order. This is the order, my lord, your lord.
This order you want to recall. What is the wrong in the order?
But as
Your
per the
submission, where you have stated that this submission has been wrongly recorded.
in my
IA 1075.
My IA 10751.
Yes, show me.
Paragraph 1, that the aforesaid writ petition was listed on 15/5/2024. On the same day, a copy of the affidavit filed in court was served on the counsel for the petition. In para 12 of the affidavit speaks as follows: that it is further submitted. That is the instructions, my lord. I stated that instructions they have submitted before the court, my lord. That it is.
Madam, you were the petitioner in the writ petition.
My lord.
That means you might have come before this court challenging a particular order of the tribunal. I am told by my brother that you challenged the order dismissing your contempt application. In that, if you have made certain submissions, that means you do not want to pursue your contempt application. As you are already paid the salary, and your name is also included in the pension scheme. Now, why we want to recall? Where is the wrong in the recording of the order?
In my writ petition.
You have not stated in the petition that you never submitted this.
No, my lord. Perhaps I am not.
You do not know the Supreme Court judgment. That is what I am saying. Please, can you open AIR 1982 Supreme Court page 1247 or 1457? State of Maharashtra versus Ramdas Srinivas Nayak. Please find out that 82 Supreme Court. The AIR, I know. SCC is also come there. you just write Ramdas Srinivas Nayak, State of Maharashtra versus Ramdas Srinivas Nayak.
Okay.
No, Ramdas Srinivas Nayak. The state of Maharashtra is the appellant there. Yes. What is the judgment? PIR 1982 Supreme Court 1249. So I was very close, 1247. Please read this judgment. Scroll down. Look at the language which is used. Just go down. Let's go. It says, matter of judicial records are the counters in the game of litigation. Look at the language, so beautifully written. We are bound to accept the statement of the judges recorded in their judgment as to what transpired in the court. We cannot allow the statement of a judges to be contradicted by the statement at the bar or by affidavit and other evidence. If the judges say in their judgment that something was done, said, or admitted before them, here is the case, your submission was recorded. That has been the last word on the subject. The principle is well settled that the statement of fact as to what transpired at the hearing recorded in the judgment of a court are conclusive of the facts so stated, and no one can contradict such a statement by affidavit or other evidence.
Here, my lord,
If the bench has recorded what you have made a submission,
here, my lord, I
then
have
in
not.
that event, that is the petitioner.
My lord,
Who was the petitioner?
I am for the petitioner here, my lord, central on the basis of instructions submitted by the Central Government Council.
Where is the order?
My lord, 15/5/2024, Annexure 1 to
Sir,
Phase 6.
no, sir. The Central Government Council submitted. But thing is that she has admitted in.
So what can be done?
Here, my lord, my read petition. I'm sorry, my lord. I'm unable to convince your lordship, my lord.
Yes. You.
Paragraph 14 and 15 of my read petition, I have
Ma'am,
listed.
what was your prayer in the writ?
Your lords.
What was your prayer in the writ? Please come to that first.
To quash the order dated 15/12/2023 under Annexure 10, that is the in contempt.
Okay.
To direct the operative to comply the order dated 12/3/2018 passed in TA number 34 of 2000.
And what order was passed in TA?
In TA, my lord, page 24. In view of the above, the respondents are directed to take necessary steps and pass orders within 8 weeks from the date of receipt of this order for regularization of the applicant from the date of their initial appointment with all consequential benefit by following necessary rules.
So that's the court has rejected the
Contempt.
disposed of the contempt, did not interfere with this order. Then why recalling?
No, my lords.
Your only claim right now is with regard to arrear payment.
My lord.
But you have admitted that your service has been regularized.
During pendency of the
Whatever it may. On that basis and on the statement of the Central Government Council, the read petition was disposed of.
That day, on 15/5/2024, Learned Central Government Council stated.
Yes. But thing is that right now you are only having the prayer for arrear salary.
Yeah.
If at all you are you require that arrear salary and the order is not properly implemented, then you go to the CAT. Then it's a CAT matter.
CAT matter.
You can go to CAT then.
CAT, my contact.
Sorry, my lord, I'm.
Limitation.
No, my lord, I'm unable to convince your lordship, my lord. In contempt, my contempt petition has been dropped against that order. I'm before your lordship, my lord.
That has already been addressed to while passing the order. You didn't raise any objection to that when the matter was dismissed. The order was passed by this bench in your presence.
In my presence, they have stated that in their instructions, they have stated that within a period of 15 days, they will pay all the difference.
No, not like that. You please read the order.
The scope of the writ was only in relation to contempt.
Yes, sir.
Beyond this.
In paragraph, I have stated in my IA, my lord, they have submitted a affidavit without any number.
There are two aspects. Now I notice, I just thought that it was your submission. Anyhow, it was a submission of the government. First thing is, what was the scope of the writ petition? The scope of the writ petition was that the tribunal rejected the contempt application. So, contempt application is rejected means that the tribunal did not find that the contemners have willfully or deliberately violated the order of the tribunal. So order of the tribunal remains as it is. Only consideration before the writ was that whether the order dismissing the contempt needs any interference by the High Court. The court, after recording the submission, finds that no, there is no need of interference. If you feel that the order was not duly implemented or implemented with full complements, but is a partial implementation of the order, then you can approach the CAT flagging that particular issue that look, you have said, but this is what a partial compliance, not the fullest of compliance or a full compliance of the order. You could have said, you have not done. Then how we will recall the order? And recalling of the order means there are set parameters. We can recall an order provided it comes within the peripheral of Order 9, Rule 9 principles. Or Order 9, Rule 13 principles. Even 151 is applied, there is a limitations, inherent powers. Why will you can go and ventilate your grievance somewhere else? The court has not decided, simply did not find that the order of the tribunal dismissing your contempt application was not faulty one. That's the only thing the court did. Nothing more than that. Go there.
No, my lord. After filing of the writ petition, when this honorable court interfered, they have regularized and included my name in the old bench.
This is what is not the interference of the court, because the court did not say anything on this. Only this writ petition was pending before this court. So they scented something that may happen. They complied the order.
But
They complied. It is not the High Court's order which was complied. It was a tribunal's order which was complied. Because the tribunal directed regularization from the anterior date. Meaning thereby from the date of your initial appointment. If you say that the consequential benefits means the differential amount of salary is also required to be paid, you have to approach the tribunal.
in a separate,
Should we assume the advisory jurisdiction?
No.
This is your baby, you have to nurture. Why should we advise you what to do and what not to do? We are not assuming the advisory jurisdiction.
No, sorry.
So you did, but we do not find that there is a fit case for recalling the order. There is no element and no case is made out for recalling. In your petition, if you look at, you have not spelled out anything on that. Very casual way of drafting the recalling application. Absolutely casual way of drafting. Should I read your application? That's not the case. You'll have to make out a case, strong case for recalling. You have to say that I have not abandoned my claim. There was no compliance. The tribunal ought to have committed a grave error because the differential salary was not paid. Yes, I'm reading for you. This is your application 10751. Is a recalling application. First paragraph listed on 15/5. Same day, copy of the affidavit filed was served on the counsel for the petitioner. Paragraph 12 of the affidavit speaks this. Quoted it. Then, however, during the course of the hearing, it stated that he has received the instruction that the relief claimed by the petitioner has already been granted to him. As such, he has been paid his salary and his name has been included in the pensionary scheme. This is what the happening, which is recorded in the order. On the basis of the said submission, the writ was disposed of. This is also borne from the record. A copy whereof is annexed. Then two, it is humbly submitted that you have put more T. It should be though. You have written thought. Anyhow, though the petitioner has been enrolled under the old pension scheme and has been regularized from the date of his initial appointment, but differential area has not been paid. Is this a ground? You have to say that you did not abandon your right. You argued this matter. This was not considered, and it was considered on the basis of this. All these statements has to come. The pleading has an importance. I think somebody is going to give a lecture today on the pleading. The importance of a pleading. What is required to be pleaded? This is what the recalling on that say. What was your role on that day? Will you not spell? Nothing. Sorry, I am badly groomed. I am very badly groomed. You'll have to make out a case for recalling, madam. What transpires on that day? What happened on that day? This is what is the. They are still in contempt. Everything you have to, something you have to plead. What to do with this application? Tell us. It deserves. There is no question of any recalling of the order. And now take the steps what to do. This is an application for recalling an order dated 15/5/2024 passed by the coordinate bench.
my lord. Yes.
Oh, for very good reason, it will be noted.
My lord has done our work.
Yes, thank you.